Daniels case is a case that came before the Federal Court of Canada. It dealt specifically with whether or not non-status Aboriginal people, as well as Metis people, were Indian. That is, Indian as defined within the British North America Act of 1867. But in the 20th century, in the 21st century, it becomes a little unclear. And so in 1999, Harry Daniels, who is the leader of the Congress of Aboriginal Peoples, sued the federal government and says, we're Indians, right? And the federal government has responsibility for us, right? And the federal government says, no, we don't, right? The only people who are Indians under the BNA Act are those people who live on reserve or are status. That is, they're in some way, they're associated with a reserve, right? And there's more than 640 reserves, I guess, across Canada. So it's not until, I believe, until 2011 that we actually get to trial. And along the way, some point, I'm contacted by lawyers who are representing the Congress of Aboriginal Peoples and asked to testify. They asked me several questions, but the biggest question they wanted to know was, what were the broader objectives of Sir John A. Macdonald and George Etienne Cartier and others who are at the Charlottetown and Quebec conferences? What were the broader objectives of Section 9124 when Indians and lands reserved for Indians were given to the federal government as responsibility? And the second question was, who did Sir John A. Macdonald and George Etienne Cartier and others, who did they intend to be encompassed by this idea of Indians? For a lot of different reasons, it's not exactly clear who these people are. And this is the result of a long history of intercultural as well as interpolitical and intersocial relationships between Aboriginal people and Europeans and others. But these people identify themselves as Aboriginal. There's this sort of pattern of people moving on and off reserve all the time. I mean, even though the land in southwestern Ontario and southern Quebec is very rich. So what did they do? Well, they continued to hunt, they continued to fish. They made baskets, they made various items that could be used by farmers. Well, those things could only be found off reserve, right? And so that's where they lived. The colonial governments really had to work out a legal system about how they're going to deal with this amorphous group of people, some of whom have intermarried with whites or non-Aboriginal people, some of whom haven't. And what happens when we have non-Aboriginal people moving on to reserve, and that's what happens. Well, in order to do that, we have to define who's an Indian and who's not. But that's not a simple process, right? Because then it comes into conflict with places where there's a lot of intermarriage, and all of that territory, and what we know today is, of course, Alberta, Saskatchewan, Manitoba, and Northwestern Ontario, it's all occupied and used by Aboriginal people in an extensive way. And you also have this other group called the Métis, who are a result of intermarriages between French and English traders and Aboriginal people. And they have emerged as a distinct community in Western Canada and Northern Ontario. Now, they could have just done, what the Americans did, which was just run roughshod over the Aboriginal people. But the Canadian government, right, and this is really what Sir John A. and I think others are thinking in the 1860s, is they can't do that because they don't have an army, they don't have the money in order to fight a series of wars with Aboriginal people in order to build this railway. And they don't have time, because if they don't build that railway really fast, as soon as they possibly can, the United States is going to move northward under various pretexts and take over that land. They've got to sign something. They've got to get deeds in which those people out west say, yes, we surrender this land, and we surrender this land to the federal Canadian government. That's what they need, and they need it quickly, and then the railway can proceed. Well, the decision of the court at the end was that this group, who were represented by the Congress of Aboriginal Peoples, that is the Métis and non-status people, were Indians. And the federal government has appealed that decision to the Federal Court of Appeals. And it's possible that regardless of who wins at that level, whether the federal government wins or the Congress of Aboriginal Peoples wins, that decision will be appealed to the Supreme Court of Canada. This would have enormous consequences for the federal government, because it would mean that they had a fiduciary responsibility, that is, they had a financial responsibility, as well as a legal obligation towards Métis people. as well as those people who had lost their status, non-status people, as well as off-reserve Aboriginals.